In 1995, just 1 year into South Africa's new democracy, the newly formed Constitutional Court made a decision that would rewrite our legal history and echo across the world. This is the case that abolished the death penalty, but it's about much more than that. It's about a nation choosing justice over vengeance, and beginning the journey of transformative constitutionalism. Makwanyane and Ubuntu were convicted of multiple murders and sentenced to death under the laws of the time. But by the time their appeal reached the newly formed Constitutional Court, South Africa had adopted a transformative, the interim constitution of 1993. For the first time in our legal history, every law had to be tested against a Bill of Rights. And the ultimate question in this case became, does the death penalty pass that test? The court considered 3 key questions. Does the death penalty violate the right to life, Section 9? Does it undermine human dignity, Section 10? Is it cruel, inhuman, or degrading, Section 11(2)? And if it does, can these violations be justified under Section 33? The Limitations Clause? Chief Justice Chaskalson led the majority opinion. He ruled that the death penalty violated all 3 of these fundamental rights, and could not be justified.
The right to life and the right to dignity are the most important of all human rights.
Justice Mohammed added,
state-sanctioned killing is always degrading.
The court held that no amount of deterrence or retribution could justify the cruelty and finality of execution. The reason for the decision: the death penalty violates the fundamental rights to life, Section 9, dignity, Section 10, and protection against cruel, inhuman, or degrading punishment, Section 11(2), as entrenched in the interim Constitution of 1993, and these infringements cannot be justified under the Limitations Clause, Section 33(1).
Death penalty is inconsistent with the values of human dignity, respect for life, and freedom from cruel, inhuman, or degrading treatment or punishment, which lie at the heart of the Constitution. It cannot be justified in a society based on human rights, dignity, and the rule of law. Right to life, Section 9. The state cannot lawfully take life unless justified by the Constitution. Capital punishment is an unjustifiable infringement. Human dignity, Section 10. Every human being, even a convicted criminal, retains inherent dignity. The death penalty denies the possibility of rehabilitation and treats the person as beyond redemption. Cruel, inhuman, or degrading punishment, Section 11(2). Execution by the state, combined with the suffering on death row, is inherently degrading. Limitations Clause, Section 33(1). Even if rights may be limited, such limitations must be reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. Deterrence and retribution are insufficient to justify capital punishment under this standard.
The reason for the decision was not just that the death penalty was harsh, but that it was inconsistent with the founding values of South Africa's new constitutional democracy, dignity, life, and the rejection of cruel punishment. The court ruled that constitutional supremacy required all laws, even those backed by public opinion, to comply with these foundational rights. The rights to life and dignity are the most important of all human rights and the source of all other personal rights in Chapter 3. The question is not whether the death penalty is an appropriate punishment for murder. The question is whether the Constitution allows it.
Justice Langa introduced Ubuntu into the heart of constitutional interpretation.
Ubuntu places some emphasis on communalism and the interdependence of the members of a community.
Ubuntu reinforced that every person is redeemable, that dignity is not conditional, and that justice must be restorative, not just punitive. Versus Makwanyane is one of the most important examples of transformative constitutionalism in action. Coined by Professor Carl Clare, transformative constitutionalism is the idea that our constitution isn't just a legal rulebook, it's a blueprint for changing society. It aims to move South Africa from a legacy of oppression to one of equality, dignity, freedom, and justice.
This judgment, rejected apartheid-era legal culture rooted in retribution, affirmed a new culture of constitutional rights and values, elevated dignity and life over vengeance and fear, introduced African philosophical values into constitutional law. The court didn't just interpret the law, it reimagined justice through a democratic and human rights lens. It is only with dignity and respect for life that a society can heal from its past.
For law students, Makwanyane is essential reading, not only for what it held, but for how it held it. The judgment looked at international human rights law, rejected the US model of death penalty retention, and forged a uniquely South African jurisprudence. It taught us that constitutional interpretation is moral, not mechanical.
Today, S versus Makwanyane stands as a pillar of the human dignity, constitutional supremacy, transformative justice, judicial courage. It tells us that courts are not just referees, they are agents of change. And that the Constitution is not just a document, it's a living promise.
If you're a law student, a lawyer, or just a citizen who cares about justice, read this case. Study it. Quote it. Let it shape how you see the law. Because S versus Makwanyane wasn't just about ending the death penalty. It was about beginning a new legal and moral order. This is South African Law Questions and Answers. Know the law. Shape the future. Question more, learn more. Like, comment, subscribe. Thank you for watching.